and welcome to your Construction Safety Association of Manitoba's 2025 Safety and Health Week virtual webinar series. Safety and Health Week is an annual occupational health and safety celebration. Safety and Health Week focuses on the importance of preventing injury and illness in the workplace and raises understanding and awareness of safety and health issues. My name is Megan Story, and I'm the Training and Development Manager of the Construction Safety Association Manitoba. And we are proud to be recognized as your premier and trusted source for safety and health information, resources, training, and core certification. Today's virtual webinar is an example of how we are striving to provide you with practical and relevant information to help with accident prevention in your workplace. For those of you who know CSAM, quite simply, our answer is yes. How can we help? We will have the answers to your safety questions, or we will find the answer with the help of our qualified resources and partners in safety and health. Today, I am pleased to introduce Melissa Hyytiainen. In today's webinar, Melissa will walk us through the adjudication process for psychological injuries under WCB legislation and policy. Melissa will provide clarity on how to navigate claims and support safe, timely return to work. So please note that this webinar is being recorded and a copy of Melissa's presentation will be made available. So at this time, Melissa, I will pass it off to you.
Thanks, Megan, and good job on the last name. Very impressive. Hi, everyone. Thanks so much for joining us this afternoon. Today's session is going to, as Megan said, we've titled it Understanding Psychological Injuries. It's a guide to WCB legislation. As Megan mentioned, my name is Melissa Hyytiainen. I am the Director of Prevention and Return to Work Services at Safe Work Manitoba, a division of the WCB. Today's session, we're going to look at psychological injuries, and more specifically WCB legislation as it relates to this particular type of workplace injury. I'd like to thank Megan and the Construction Safety Association of Manitoba for inviting me to present this topic during Safety and Health Week. So a little bit about myself. I've actually been with the WCB for about 20 years. Prior to moving to Safe Work in 2024, I worked in the Compensation Services division of the WCB. I consider myself I'll call it a student of the business. I started out working as an adjudicator as a summer student, ended up, moving into a permanent role in adjudication, and have worked my way through a variety of different positions with the board, including case manager, supervisor of the occupational disease unit, and most recently manager of short-term claims. That is before moving to Safe Work. My area of focus really since 2014 has been on the adjudication of psychological injuries. Also occupational diseases, including noise-induced hearing loss and fatality claims. And really in moving to Safe Work, I've been able to bring that claims experience to these areas as it relates to prevention and return to work services. Okay, so we'll be about an hour today. I do want to allow some time for questions at the end. So I'd say if there's anything that pops up, feel free to put it in the chat. And then we can definitely make sure we address it at the end of the session today. We know there's a significant focus on psychological health and safety at the moment. I'd say this has been an area of growing concern over the last number of years, and it continues to be an area of focus for us at Safe Work as well. We know it's an area that employers and individuals are also wanting to learn more about. So I'm just looking, I see we've got 34 participants today, and I think that's great. It's a really important topic, and I think the more we can provide awareness and understanding in terms of how we look at these types of injuries, just the more clarity it provides to employers as to what they can do in terms of prevention. So our focus today is going to be understanding psychological injuries and the applicable legislation from a workers' compensation perspective. Promoting and strengthening psychological health and safety is an important part of a safety and health management system. And improving psychological health and safety within your workplace so that psychological injuries can be reduced and ultimately prevented should be a focus for both workers and employers. Despite this focus, we also know that psychological injuries are becoming more common in workplaces, and they're resulting in increased claims to the WCB. Causes of this are multifactorial. In today's session, I will provide you with a review of the legislation as it pertains to work-related psychological injuries. I want to be specific on that because there are other types of psychological injuries that may be non-work related, and they're still important to be aware of as an employer so that you can support these individuals. This will include some discussion around investigation from the WCB standpoint, the adjudication and decision-making process. Towards the end, we'll also touch a little bit on medical management and treatment, as that is a very important part of these claims, as well as return to work considerations for individuals that have sustained a psychological injury. Okay, so let's start with some background statistics, because I think that gives some context as to why there's such a focus on these claims right now. So what we have here is a visual representation of accepted psychological injury claims compared to total accepted claims received by the WCB for the years of 2019 to 2023. So in 2019, for example, WCB accepted 27,500 claims total. Okay. Of those, only 345 were for psychological injuries. Moving forward to 2023, we had accepted 25,600 claims at the board, with 567 claims being for psychological injuries. When we look at the 5-year trends here, though the numbers are very small in comparison to the total volume of accepted claims year over year, it's important to note that the prevalence of accepted psychological injuries is increasing. And in the period of 2019 to 2023, that was a 64% increase in the number of claims accepted as it related to psychological injuries. While these claims represent a relatively small percentage of the total number of accepted claims received each year, they're also some of the highest in cost and duration. In terms of representation, I think it's important to note the highest volume of psychological injury claims at the moment comes from the public administration sector. So this includes occupations such as police, firefighters, paramedics, correctional officers, really your first responders. A few other stats I just want to highlight. There's sometimes a question in terms of, this is what I'm presenting here is a number of accepted claims that we receive. There's certain claims that we disallow for various reasons. So if we want to consider 2023, in total, the Workers' Compensation Board received just over 27,000 claims. In terms of the acceptance rate, that's about 94%. In the same year, we had received 905 psychological injury claims. But you'll notice we only accepted 567. So that was a 63% acceptance rate on these types of claims. There are various reasons why a psychological injury claim might be accepted, which we will get into as we go into the policy discussion. Looking at the total, psychological injury claims compared to non-psychological injury claims, at present, we only receive like 3.3% of all claims received are for primarily psychological injuries. Okay, so a lot of statistics. Okay, so how does construction sector stack up compared to what I've just told you? So you'll notice the orange is barely visible on this graph we have here. And that's because the number of psychological claims received from the construction sector each year is so low that I cannot actually provide you with the actual numbers for each year. The numbers are so low, they could actually be identifying to people if I told you. But what I can tell you is during that 5-year period of 2019 to 2023, a total of 15 psychological injury claims were accepted from the construction sector. Psychological injury claims from the construction sector during that period represent just 0.07% of all psychological claims accepted by the WCB. So we often think about, why is this sector underrepresented? Certainly the work involved in construction is not the same that you would see in public administration, where you're dealing with, those first responder type jobs where you were going to accident scenes, you are responding to people with serious injuries, you're working in correctional institution environments. We know it's not the same, but we do think there is some underrepresentation in construction. There are a few reasons for that. Stigma is sort of a big piece. Often we find that, I'll call it a little bit of an old school mentality, but if there is that mindset that, you don't talk about your feelings, you just deal with it on your own by whatever means, you choose. We still find at the board there is a lack of awareness out there that the WCB does accept claims for psychological injury. So I think that's a really important part of even just the awareness of that these are an important type of claim, and we do accept claims for these conditions. And we also know there is general underreporting, and sometimes that just relates to the fact that individuals don't know they can report, or they think they will get over whatever happened or manage it themselves. Occupations within the building construction sector, as I said, we know they're inherently different from public administration or healthcare sectors, for example, where we see sort of the highest prevalence of these types of claims. We know the nature of work is different, and many of the hazards workers encounter are different. But there are still hazards that exist on site, and when there are hazards, there is still that risk of a psychological injury. Okay, so this is where we get to the exciting legislation and policy. So for the purposes of our discussion today, we're going to focus on the legislation as of January 1st, 2022, when the Workers' Compensation Act changed under Bill 18. A prior version of the Act did not treat physical and psychological injuries in the same manner. But since January 1st of 2022, psychological and non-psychological injury claims are adjudicated in the same way. So this is our definition of accident that we have on the slide. Specifically, it says subject to a 1.1 definition of accident. It includes includes a chance event occasioned by a physical or natural cause. Okay, so what is a chance event? These are examples we often talk about. It could be a building collapse. It could be a fire. It's something that occurs by chance. It can be a willful and intentional act that is not the act of the worker. Types of claims that fall under this part of the definition would be bullying, harassment, even acts of violence. So things that occur to someone that is not the act of themselves. And then we have an event or condition or combination of events or conditions related to the worker's work or workplace. As we consider psychological injuries, what falls within this piece of the definition is what we call traumatic events. So it could be a traumatic event, it could be a series of traumatic events occurring in the workplace. It could also be excessive workload, which I'll touch on later, which is another type of traumatic event. For a claim to be acceptable, the definition of accident must be met. Subsection 1.1 speaks about the different types of things that could cause an accident, but the key thing is that accident also results in personal injury to a worker. So that can include an occupational disease, it can include post-traumatic stress disorder, which is a type of psychological injury, or an acute reaction to a traumatic event. I do want to highlight the reason that post-traumatic stress disorder is sort of called out in this part of the definition is that there is separate legislation that speaks specifically to post-traumatic stress disorder as being a presumptive type of condition. We'll talk about that a little bit more as we get into the policy piece. So we talked a few slides ago about the acceptance rates for psychological injury being lower than sort of the general claims population. So there's a number of reasons for that, but the primary one is that there are situations that are outlined in the Act that actually do not meet the definition of accident. The definition of accident under the Act is subject to subsection 1.1. So this excludes certain events or acts from being accidents. The exclusions are any change in respect of employment, which would include promotion, transfer, demotion, layoff, or termination. Any stress that would be experienced in relation to those events, which you could understand that something like that could be stressful, is not considered to be a psychological injury. So when we receive claims that are related to those items listed under A, that falls under the restriction in the definition of accident, and those are claims that we do not accept. Those events are considered what we call everyday workplace events between an employer and a worker. Okay, so they do not constitute an accident under the Act. Similarly, an event or condition or a combination of events or conditions that produce mental stress are also not accidents under the Act, unless the mental stress is an acute reaction to a traumatic event or PTSD presumption applies, which I said is a separate piece of the legislation. If a worker is having psychological difficulties, but it's not the result of a traumatic event or events, but rather due to the daily pressures of worker life, that is not considered an accident under the Act. If a worker is exposed to a traumatic event or events that are specified as triggers for PTSD in the DSM-5, DSM-5 is the American Psychiatric Association's professional reference book, so that's the most current version, that's the one that we reference. The worker was diagnosed after 2015, because that is when the PTSD presumption came into the Act. In those cases, PTSD is presumed to be caused by the employment unless the contrary is proven. So that is a mouthful in terms of the PTSD legislation. I'm not going to focus a ton on the different types of diagnosis. I'm just going to focus on what is considered a compensable psychological injury. I do just want to highlight that though there is a presumption in the Act as it relates to PTSD, we do find that many instances that would result in person having a PTSD diagnosis actually fall under the acute reaction to a traumatic event piece. So typically those claims are accepted under sort of the regular definition of accident rather than requiring use of the presumptive legislation. Okay, so what is a traumatic event? I think it's something that I've talked about a little bit already. So as per the adjudication of psychological injury claims policy, the WCB considers a traumatic event to be an identifiable physical or psychological occurrence which takes place in a discrete time frame, is not a series of minor occurrences, and is reasonably capable of causing serious psychological harm consistent with an acute reaction. When we think about what traumatic events are, I think it's important to have a discussion about that piece. So let's talk a little bit more specifically about traumatic events. I will note there is a QR code here. I will share that the WCB and Safe Work Manitoba have revamped their website as of Wednesday. So the code will take you to our website. It does not take you specifically to the policy at the moment, but you can certainly find the adjudication of psychological injury claims policy under our policy manual. Okay, going back to traumatic events. So they include events that involve direct exposure to actual or threatened violence or harm at a specific time and place, or potentially workload over a period of time that is excessive or unusual in intensity. So I think when we talked earlier about the types of sectors where we receive psychological injuries, we know that construction is underrepresented. Many of those claims come from types of occupations where you would expect there are psychological hazards existing. So those are your first responders, those are your healthcare workers, your correctional officers. But when we think of a construction site, there are potential things that might occur that could be considered traumatic. So let's think about, if you're on site and you witness someone get injured. As seeing that could be considered a traumatic event. Sometimes there are situations where, unfortunately, there are fatalities on sites. The individuals that have witnessed something very traumatic. That could be a type of event that may cause a psychological injury. Even on a site, there may be these near miss incidents. So I know there's different terminology around near miss, but what we're going to talk about in this case is where the potential for something to happen was very real. The outcome could have been dire, but it didn't happen. Something like that can still cause a stress reaction to a person, whether it be you had witnessed it or whether it be that near miss actually happened to you. Things like that can actually be considered psychological injury as well. The other things that we typically see relate to bullying or harassment. So, sometimes not everybody is getting along, and definitely we have seen, claims for bullying and harassment through, construction and other sectors as well. Excessive workloads is also a type of traumatic event now. I know that one is causing a lot of a stir in terms of how many claims we receive, who's going to file. Because I think when you think of excessive workload, people think about, terms such as burnout and things like that. Life is busy, work is busy. I think there's, it's not unreasonable to think that at times people might feel that they are overworked. I will take us to the next part of the slide here, which we'll talk a little bit more specifically as to what we consider excessive workload to be. So excessive workload is actually something that came into effect May 1st of 2023. It was in addition to the adjudication of psychological injury claims policy. So actually it has been in effect for 2 years now. What it specifies is that coverage really was extended to psychological injuries arising from excessive workload. Excessive workload, as I said, is pretty open for interpretation, but in terms of the policy, we do have very specific criteria. So those criteria, they do talk about determining whether excessive workload constitutes a traumatic event involves both a subjective or objective analysis. Not every instance of perceived excessive workload will give rise to a compensable claim. So when we do look at these types of claims in particular, we consider the worker's subjective statements and their response to the workload. We must also determine that the workload is significantly different from the workers or their coworkers' usual workload and is of sufficient intensity and duration that a reasonable person in the worker's situation might be expected to suffer an injury. So a few things I want to hide out there. They talk about perception. And I think everybody perceives things different, whether it be excessive workload, whether it be traumatic. Everyone comes to us in various states of disrepair, I'll say. And your life experiences up to the point of experiencing a traumatic event are often going to determine how you react to that traumatic event. And so what we find is that, what is traumatic to one person may not necessarily be considered traumatic to another. Similarly, and that's the perception piece, right? So when we look at excessive workload, I will say we haven't received many of these claims to date. When the ones we have received, though, have been very interesting to investigate because there is a matter of a worker's perception, and then there is the gathering of objective information as well. And in weighing that out, we need to determine, if it meets that criteria in the policy. So they talk about, workload that is significantly different from the workers or their coworkers. I think that, when excessive workload came in, it was very much thinking about healthcare, for example. Okay, so individuals that have potentially been, mandated overtime, things like that. So you might have been hired to do, say, a part-time position, a 0.5, but due to various reasons, you've been working a full-time position. So when we look at what is different from sort of the typical, we look at, okay, what were you hired to do in terms of, the expectations of your contract as to like how many hours you're scheduled to work, things like that. And then is that work over and beyond that? Okay. So it's got to be different from what you signed up for, or it's got to be different from your coworkers. So on the coworker front, we look at situations such as, there is like various staffing situations due to resource. So it could be a situation where somebody is, on vacation and everybody pitches in. Generally, that doesn't constitute excessive workload because it's usually a short time period. And also, if all the coworkers are assisting in the coverage, then is your work really different than your coworkers? It's not if everybody is sort of sharing the load. But if there's other situations where, we are understaffed, there is sort of no end in sight, and one particular person is being asked to do the work of another person for a prolonged period of time, depending on the scenario, there might be situations there that could potentially meet the criteria to be considered excessive. Okay, so it's interesting because there's the perception, there's the objective findings, the subjective findings. We also talk about the reasonable person, and I do want to highlight the reasonable person. Reasonable person is very much a legal term. So we used to use the term like the person on the bus. Okay, so a reasonable person is if you presented the facts of the case to someone that had no stake in the game. So they don't, there's no connection to the worker, there's no connection to the employer. They are just a individual being presented with the facts. What would that reasonable person think? Okay, so we used to talk about the person on the bus as being the reasonable person. Now we switched our language a little bit more to the reasonable person. And you'll see that throughout many of the WCB policies. And so the reasonable person is really a legal term that, if this was presented in a very objective way, what would this person think in terms of the outcome? Would they think that it's excessive, unusual intensity? Would they think it is not? So a little bit of an explanation about that. Okay. I've skipped a little bit ahead on this one. So again, we've talked about excessive in nature, significantly different from the workers or their coworkers' usual workload, and of sufficient intensity and duration. Okay, so sufficient intensity and duration, that really speaks to how long this excessive workload goes on for. I think, there are periods, throughout time where you might have a hard deadline and you might put in some additional hours getting to that deadline or put in extra effort getting to that deadline, but there is a deadline in sight. Typically, those situations are not of sufficient intensity and duration. Where we're looking at is really situations where there maybe is no end in sight, and it is, kind of beyond what a reasonable person in the same situation might be expected to suffer an injury. Each claim is evaluated on its own merit. I think that's always an important piece where in situations like this, I find people often want to provide, specific examples or hypothetical scenarios. And what's really important is that like it's all in the details. So, the details of one claim are evaluated on the merits of that claim. It's not in comparison to somebody else's claim. Harassment and bullying claims. So I do want to highlight these because we do receive them more than one would expect. When there was changes to the policy with respect to the excessive workload, they also added some clarifying statements around what is considered harassment and bullying. So I think it's just important to highlight. And I also want to highlight that, we've always considered claims at the WCB for harassment and bullying. We've always investigated those. They've always fallen under that intentional willful act that is not the act of the worker. However, people have different perception or interpretation as to what harassment and bullying means. So updating the policy just to be really clear on the language, I think has really helped in terms of allowing people to know exactly what we're considering when we're looking at these types of claims. So harassment means objectionable conduct that creates a risk to the health of a worker. It can also be severe conduct that adversely affects the worker's psychological or physical well-being. Bullying means conduct that is intended to or should reasonably have been known would intimidate, demean, or humiliate or isolate an individual or result in that individual's loss of dignity. Bullying often involves a real or perceived difference in authority between the parties. So I think that is a really important piece that we now note because there is, discussions that occur between workers and their supervisors or superiors. And there is, many of those will be work-related discussions in terms of performance and things like that. But we also find that a number of these situations can sometimes cross that line of just, things that occur within the employer relationship to this potentially constituting bullying. So in bullying claims, we often see there is a difference in authority between the parties. And so having spelled that out in the policy, I think is very helpful in terms of guiding our adjudicators in their investigation as well as their decisions. Okay, so how are these claims investigated? We've talked quite a bit about the policy. I would encourage anyone to, pull it up if you haven't, or, for your reading pleasure at a later date. It is very helpful in sort of speaking to the process that someone goes through when we are looking at these types of claims. So I think it is just good information for workers and employers alike. So I want to talk a little bit about how we investigate these types of claims because they can be quite sensitive in nature. As I mentioned, it's always in the details, and with these, there is a lot of details to obtain. Okay, so as with all other claim types, psychological injury claims are adjudicated by following the procedures outlined in policy 22.00, which is our decision-making policy. This covers the legal principles and concepts that must be applied when making decisions under the Act, including following the inquiry model to render impartial decisions and evaluate each claim on its own merits. The inquiry model, for those that don't know, is the investigation model that we use at the WCB. Basically, when someone does put in a claim, the onus is on the WCB to inquire and gather the information required in order to make the decision. So it is not on the worker to prove their case. It is not on the employer to prove their case. It is on the WCB to ask the questions and gather sufficient information in which to render a decision in accordance with the Act. To determine whether a definition of accident has been met, the short-term claims adjudicator develops an investigative plan for each claim. The nature of the worker's injury determines what that investigative plan will be. So, for example, when a claim is filed, we receive a worker's report, an employer's report, typically some medical information. The extent of the investigation is really going to depend on, what information has been provided and where we need to fill in the gaps. So, very straightforward example in terms of a physical injury would be if someone has filed a claim for a cut hand, the worker confirms they reported it right away, it happened at work, the employer confirms the same, we have a doctor's report from the same day showing that the person has a cut, sought medical attention, what have you. There's not much additional information we need in terms of to know what happened. Like all those pieces have been satisfied. It gets a little bit more complex with psychological injury claims because often It may not be a specific event. It may be accumulation events. It may be that someone is delayed in filing the claim with us due to various reasons, whether that be the stigma, not knowing that they could file, or just feeling that they could deal with it on their own. So anytime we get a new claim, regardless what type, we look at the information we've received and we make a plan to gather the missing information or the information that we feel will be needed to make that decision. So in doing that, the adjudicator reviews the information available on the claim file. They work out what additional information is required, and they identify who might be able to provide that information and by what means. So in some cases, that might be reaching out to the employer to gather additional information as to what the worker has reported or what's kind of issues have been occurring over the last period of time. Sometimes it is speaking to a coworker where maybe a worker hasn't come forward immediately to the employer to report something, but there's somebody that they work really closely with and they've been sharing, with them some of the struggles that they've been having. We might want to reach out to that person to get a bit of a sense. So typically, we gather information from workers first and foremost, then employers, coworkers, and any treating healthcare providers. I will want to say, investigative process is often not linear, and additional information might be needed to gather after analyzing what is gathered initially. So what I mean by that is that typically, one question might lead to another question. Sometimes the initial information we have is very basic, and as we start asking additional questions, the picture becomes a little bit more clear, or it might actually become more murky and we need to talk to some more people. So it is a very much, it can be a complex process, particularly with psychological injuries. The other things that we keep in mind is that, individuals that are often suffering from a psychological injury, it may be difficult for them to talk about what's occurred. So sometimes because of that, we do need information from the worker, but that initial phone call might not be the right time, or it might get too difficult for them to talk about what has occurred. We have taken some steps to try and prepare people for what information we need from them. So in some cases, if we can't get a hold of a worker right away, we send a letter in advance, just sort of explaining the information we're going to be asking and why, and it gives them an opportunity to sort of get their ducks in a row and gather the dates of those medical appointments, think about who they talk to, and then they're prepared for the discussion. Psychological injuries can be very, they're very personal. It relates to how somebody is psychologically impacted by something that has occurred. So as adjudicators, we want to be very mindful of that process when we are asking those questions. So in the adjudication piece, once satisfied that there is sufficient information to make a decision, the adjudicator will move on to the decision-making steps. As I mentioned, the length of time needed for that process varies. It really depends on what happened and how long ago, the emotional state of the worker and being able to, speak to us about what's happened, and really how easy or challenging it is to obtain the required information. For example, I will say bullying and harassment claims are some of the most complex ones that we deal with. And often it is because there is a lack of witness to events. It's usually something that happens between the worker and the other person. There may not be witnesses. How do we obtain that information, right? So straightforward claims are typically adjudicated quite quickly. Those that are more complex can take more time to investigate and then to really look at the details to see if it meets the definition of accident. Okay, standard of causation. So when I started this presentation, I said that we would be looking at really just the policy after January 1st of 2022 because there had been a change. So the change really relates to the standard of causation that is used and applied to psychological injuries as well as physical injuries. So the but-for test is what we call it. It's a test of causation that applies to all psychological injuries with accident dates on or after January 1st, 2022. The test means that work activities or exposures must have been necessary for the worker's injury to have occurred. Work does not need to be the only factor or even the primary factor, but work must be a necessary factor. So this is a change in how we have approached things. This has been the standard of causation we've used for physical injuries, really since probably the beginning of the Act. But with psychological injuries, we used to also use the standard of causation of dominant cause. And dominant cause speaks to work has to be the kind of the dominant factor. Okay, so we still use dominant cause in certain circumstances with other types of injuries, such as occupational disease claims. But since January 1st of 2022, all psychological injury claims are adjudicated using this but-for standard of causation. So, investigation of a psychological injury claim, once we have completed that piece, it's really meant to answer two questions. So number one, was there a workplace accident as defined in the Act? And we went over sort of the definition of act earlier. And if so, did the worker sustain a psychological injury as a result? So it's important to note, as mentioned, work does not have to be the only factor in relation to a worker's psychological injury, or even the primary one for the test to be met. But work must be a necessary factor. So that is saying the injury would not have occurred but for this incident that happened at work. Okay. We know that a worker could have other non-work related things going on in their life, and typically they do, as we all do. However, that doesn't preclude them from having a work-related injury. I'm going to expect some questions on that one later, so I'll save till the end. Okay, medical management and treatments. So we've gone through the process of investigating the claim. We have weighed that evidence. We have considered the facts against the Act and the policy as it's described, and now we have an acceptable claim. So once a claim is accepted for a psychological injury, appropriate and associated medical expenses are covered by the WCB, which may include treatment from family physicians, psychologists, psychiatrists, and any related medications. As needed, Workers' Compensation Board may also arrange for a referral to a psychologist to provide the worker with early access to treatment if they are not already being referred by their family physician. This early access to treatment can actually take place prior to the adjudication of the claim. Reason for that, there is a shortage of psychological treatment providers in the province of Manitoba. And we do know that early access to treatment is very important to a person's success in recovering from a psychological injury. Early access to treatment is often with a psychologist, and that is not something covered by Manitoba Health. So a number of years ago, we made the decision as a board to arrange for early access to treatment for those that are not currently involved with a psychological treatment provider as a means of getting them, early access, but also in treatment quickly to help assess their psychological condition. And it also helps us with the adjudication process as well. There is wait times for psychological treatment in Manitoba. So really, if someone has raised their hand to us that they are not currently involved with a mental health treatment provider and they are wanting us to arrange access to treatment, we will do our best to, contact providers in the community and get someone involved in their care. Generally, if a worker's recovery is expected to be longer than 8 weeks, the file is reallocated to a case manager. The case manager will continue to monitor the worker's treatment and recovery. This is done by reviewing medical reports from treating healthcare providers and by engaging in regular discussions and meetings with the worker to ensure an understanding of how they're progressing and when they will be ready to return to work in some capacity. What I do want to point out here is that not every person that sustains a psychological injury also has time loss. There are many individuals that we deal with that they have had something occur, it's determined to be acceptable, we arrange some sort of medical treatment for them, and they are otherwise able to stay at work. That is very common. We also have the other side of the spectrum where, individuals are very challenged by their psychological injury and work might not be appropriate for them. That's often dependent on what their work is, because when you do think of a psychological injury, it's often involves your ability to concentrate. You might be not sleeping well due to either medications or just being up at night due to ruminations and things like that. So a psychological injury can really impact someone's ability to kind of bring their best self to work. But I do want to highlight that not everyone with a psychological injury is going to be off work. That's just not something that we see. In some cases, work actually, is good for their recovery. And they feel that their condition might be worse if they were to actually take that time off work. So it's very much individual specific based on sort of where they're at, but that's just something I wanted to highlight. So return to work considerations. A worker's readiness to return to work is based on their own self-assessment, as well as that of their treating healthcare providers. The WCB is committed to helping injured workers return to safe and suitable work as soon as medically possible. So most of the time, the employer and the worker will arrange the return to work plan together. The WCB claim owner will become involved in situations where the employer requires either financial or technical assistance, or if the worker and employer disagree about whether the modified duties are appropriate. A return to work plan is more likely to be successful if the employer shows support by keeping in regular communication with the worker throughout their recovery. I cannot highlight that piece enough. When someone is dealing with a psychological injury, if they have the support of their employer to return to work in some capacity when they're ready, or even just a matter of like maintaining that connection to the workplace through conversation, through checking in on them, the outcomes of return to work are that much better. Employers should participate in early return to work discussions with the worker. And when a return is imminent, they can determine the appropriate modified or alternate duties, potentially on a graduated basis, and per the restrictions and capabilities to confirm what supports are needed. Some more supports when someone is returning, particularly if they've been off for quite some time, might include preparing coworkers for the worker's return and what that looks like. If the worker's been off for a longer period of time or a number of changes have taken place in the work environment, the employer might consider a reorientation session or day. Documented return to work plan is optimal, and regular follow-up with the workers subsequent to their return to work will ensure that any issues are addressed in a timely manner. We do know that most people are very comfortable with returning someone from a physical injury. I think a lot to do with that is the fact that physical injuries are actually quite objective. You can see them, and people, understand that if someone, for example, has a broken leg, they might be able to modify it with some seated work where they can put their foot up. Psychological injuries are a little bit trickier because you cannot see them. And so we understand that. We do have at Safe Work, we do offer some return to work basics courses, which I think deal with some very basic kind of concepts as it relates to appropriate alternate or modified duties. We are in the process of actually working on a complex return to work workshop, which is going to deal specifically with psychological injuries and other complex injuries, because we do know that those are some of the most challenging ones that employers deal with it when it comes to returning individuals to work. Going back to the return to work plan, the claim owner, so whether it be the adjudicator or the case manager with WCB, will continue to follow up with both the worker and employer until the worker has resumed their full regular duties, is doing well, and their treatment is concluded. At the point that treatment is concluded and they're back to regular duties, they are essentially considered recovered from their compensable injury. Okay. So aftercare. Subsequent to a worker returning to work, WCB may approve additional psychological treatment to support a full recovery. What we do find is, the path to recovery is often not a straight line. So there are certain things that can occur, particularly with psychological injuries, where someone, may have a bit of a setback. So I think we think about, taking care of ourselves physically, in terms of how can we sort of maintain ourselves. So if you've got a physical job, are you going to the gym? Are you keeping up? Are you getting good sleep? Are you working, eating well? Those sort of things that help just maintain us. There's starting to be more of a similar approach to psychological injuries in terms of, maintaining some sort of contact with the psychological treatment provider, whether that be through EAP, whether that be through, someone checking in with their family physician regularly, or perhaps just a counselor. So sometimes there is some aftercare, not in every case, but it's important to know. So other aftercare might include workers' self-care plan, so created in collaboration with their treating healthcare provider, and with the employer, it might be follow-up with discussions with the worker just to see how they're doing, and the worker ensuring that they communicate any recurrence of their symptoms to the employer, the WCB claim owner, and the treatment provider. So at this point, we have just under 15 minutes left. I'd be happy to take any questions that you might have. I'm not sure if the best way to do that is through the chat.
Yes, Melissa, we'll just have anyone who has any questions, just put them in the chat. Or if those of you who have questions would feel more comfortable taking yourself off mute and asking the question, you're welcome to do that as well.
And actually, further, if we want to move to the next slide, I do have my contact information there as well. If you have a specific situation you maybe want to email me about, I'm definitely open to that as well.
Morning, everybody.
Good morning.
I don't know if this is a relevant scenario, but I know typically employers are really the recipient of, employees are, putting in the claims. Have you ever seen where it is reversed, where an employee is the actual, the harassing party or the bullying party towards their managers or, their leaders of the business. Is that a relevant scenario? I don't know if that makes any sense from an insurance perspective or not, but.
Well, I'd say it does. I'd say it's probably not the common scenario, but in this sort of situation, like, as an employer, are you speaking that, you're that person's supervisor or manager or lead hand?
Yeah, I'm just speaking
Yeah.
metaphorically, really. I've seen it before,
Yeah. Yeah.
where employees are, they feel that the business can't survive without them, and they have this carte blanche. They can do whatever they want,
Mhm.
and they just stomp around and make demands, and just
Yeah.
cause a lot of uncomfortableness in the office environment, right? And
Yes.
I just don't know if that's something that let's say I'm the supervisor, whatever. Would I actually make a claim for that? I
You
don't know.
could. You could. Well,
I
as a
guess
supervisor,
as
like
a
you would.
business, I don't know how that
Well,
would work.
as a supervisor, you would be considered a worker as well.
Yeah, no, yeah, that's true. Yes.
So like in terms of the WCB system, right? So I
Yeah,
mean,
yeah, yeah,
um, yeah, like these sort of situations, like it takes two to tangle, I'll
yeah,
say.
yeah,
So
yeah.
I mean, it's often, there's that difference in terms of
Perception and what people.
perception
Yeah,
and authority, but it's not to say that it can't be the other way around.
yeah.
So I would
But
say it's anyone could file a claim
in
for
that
something
case,
like that.
it
Yeah.
wouldn't be filed for the business. It would be filed for an individual, right? I mean, like,
Yes. Yeah. Like as a
even though
supervisor.
that person may impact like the whole front office, for example, like 6 people or
Yeah.
something. I don't know.
Yeah, like it's not exactly like claims are assigned to workers, right? So
Yeah,
whether
yeah,
that
yeah,
be sort of
yeah.
a person that's more kind of online, whether it's a supervisor or a manager, any individual that falls under the business's coverage has the ability to file a claim.
Yeah, and ultimately you'd like to, correct that behavior, but I
Yeah,
don't know if that has any supporting nature in terms of,
yeah.
that person, having a legal leg to stand on to,
Yeah. Well,
dismiss that
these are
individual. But
challenging ones because I mean, depending on the size of your business, when there are matters of bullying harassment, people have like there might be a respectful workplace policy and a process to follow through that.
yeah,
There's a lot of difference. I mean, there's the work related angle where it could be a compensation claim, but perhaps if it is something there's these interactions happening that are not necessarily work related, human rights might be another option. Like,
yeah,
so there's different options where people can go for different remedies. The challenge that we have in our investigation and adjudicating is that these things all overlap and intertwine. And so really trying to sort out, the work relatedness for the claim side is where we focus. But
yeah.
anyone
Mm,
experiencing, bullying and harassment at work, if you're covered by WCB under your business, you can file a claim as a worker.
yeah. Okay.
Yeah.
I mean, not
Good question.
simple. Definitely
No, not
turns into
simple, but it's
complex.
yes, they are. They are. But
Okay.
that is a very good question.
Nice job.
Oh, thank you.
So Melissa, there are a couple, or a comment and some questions here. The next comment
Uh,
is, seems like bullying rules would be very subjective due to the possible interpretation of disciplinary action as bullying.
that is an excellent question. And when I speak to the complexity of these claims, that is really, there are some parts where something that may start out as disciplinary action, might kind of, where is that line, right? So, I mean, we talked early on about things that are restricted from the meaning of accidents. And those would be sort of those, change in respective employment. So those are promotion, transfer, demotion, layoff, termination, the things that really are part of that employer-employer relationship, because we don't want to take away an employer's ability to manage someone, right? So it's more so where things go beyond that, where, it gets, I'll say, less objective, So sometimes it's, and the perception thing is there too. Like, communication is hard, especially in, those conflict type situations. So it's, can these things be delivered in a respectful manner? Or are there sometimes name calling, shouting, like acts of aggression, throwing papers? Like, there are things that may start out as disciplinary or, work performance and things like that, where there's a potential for it to move into the harassment and bullying is if, they're not delivered in a respectful way, if that makes sense. That's an excellent question, though, because that is a subjective piece of these claims. So when we talk about the objective piece, I mentioned there's often, these discussions often occur with just two people. So I would say sometimes if it's a disciplinary and action thing, a third person in the room is always a good idea, for both of you, whether it be the worker or an employer, because just to make sure that everybody's feeling supported in those tough discussions. I see we have one more question. Safe Work Manitoba or CSAM provide any sort of toolbox talks regarding psychological injury, safety, or mental health in the workplace? I'll speak to the Safe Work piece. So we do have psychological injury toolkits on our website. As I mentioned, the website is, we've moved to a new co-branded website as of Wednesday of last week. So safeworkmanitoba.com is no longer a website, but if you do go there, you'll get redirected. We've now are sharing space on the workers' compensation website. So all of the information is now in one place. We do have some items there in terms of, resources for training. I think there's a lot of good training out there for workers, employers, leaders. So we do have some things listed there in terms of different courses, and we've tried to specify sort of what the target audience is. We do know there's going to be changes to the Workplace Safety and Health Act coming up at some point. I think they're at the second reading, that will impact how employers respond to psychological health and safety. So we are going to be building out that toolkit further in the coming months. Megan, did you want to maybe speak to the CSAM piece?
Yeah, absolutely. So we don't specifically have toolbox talks on those topics, but we have done in the past webinars kind of similar to this format where we have had facilitators present on mental health in the workplace, as well as at our conference annually. So those are kind of avenues that we've used to present information on mental health for our members. And so in those cases, I do know we have done some recordings of these webinars in the past that you can check out on our website under resources and downloads. The webinars that have been recorded are available to be viewed on our YouTube channel, so you can check that out for specific topics on mental health in the workplace.
Thanks. Any additional questions, comments?
Thanks, ladies. That's great information sharing.
Thank you. Thanks for attending.
You bet.
Thank you very much, Melissa. Very much appreciated the discussion. Thank you all for participating in today's session. It's always great to speak and to hear from an expert in the field, and for the engagement that we receive from our members. So thank you all for taking the time to spend your lunch with Melissa and I. And again, if you do have any questions related to this topic, please reach out to myself, and you obviously have contact information from Melissa as well, and we will be able to get the answer for you should you have one. So thanks again. Be tuned in as we hope to provide you with more information on upcoming webinars. So check out our website and our YouTube channel shortly. Take care. Thanks, Melissa.
Thanks, Megan. Thank you, everyone, for attending.
Bye-bye.
Have a great day. Bye.